Next case in the cause list today is of Himanshu Real Estate versus Delhi Commissioner DGST, argued by CA Himanshu Singhal, Advocate Himanshu Singhal, sorry. And the case is about transfer and assignment of leasehold rights, applicability of GST on the same.
Himanshu is from Ropar, Hapur. He is come from Hapur to argue this matter, and he has worked very hard on his appeal.
Again, Himanshu, 1 point. Earlier said, you have not seen the procedural rules. Appeal cannot be against Joint Commissioner.
अच्छा APL 5 में भी कहीं कहीं आपकी गलती है, आपने ठीक से नहीं भरा उसको.
अपील में वो जॉइंट कमिश्नर ही आपने लिखा हुआ है.
कमिश्नर DGST.
APL 5 में लिखा है करेक्ट, लेकिन अंदर उसमें वो नहीं लिखा हुआ है.
इंटरेस्ट की उसमें इंटरेस्ट नहीं लिखा है आपने. एनीवेज अच्छा, आपने इसमें एक और गलती करी है. यहाँ पर आपने जैसे ऑनरेबल जुडिशियल मेंबर एंड हिज कंपेनियन जजेस उल्टा लिख दिया गलती से. वो थोड़ा देख लेना. बैकग्राउंड ऑफ द केस की जगह स्टेटमेंट ऑफ फैक्ट्स इज द बेटर वन. ओके, प्लीज प्रोसीड.
Good morning to all. The case of Himanshu Real Estate Private Limited.
I ठीक कर दूँ.
In my case, my client are assigned a land to XYZ Limited. The department doing the scrutiny of the case and getting the statement amount of ₹20 crore received in a bank statement. The department levy the tax of ₹3.6 crore and interest of ₹56 lakh. The department have no any evidence that this is the lease or lease of land. Are firstly when the I replied first against the SCN, then the council given the
Mr. Counsel, you can proceed in any language which is comfortable to you.
Thank you.
Yeah, please.
अभी जो SCN फर्स्ट आया था तो उसमें काउंसिल ने जो अपना रिप्लाई दिया था डिपार्टमेंट को, तो उसमें उन्होंने बताया कि हमारा असाइनमेंट है, पर डिपार्टमेंट ने उसे नहीं माना. डिपार्टमेंट ने ये 20 करोड़ की जो रिसीप्ट है उसके ऊपर टैक्स लेवी कर दिया पूरा से. और डिपार्टमेंट के पास तब की कोई एग्रीमेंट भी नहीं था, कोई डॉक्यूमेंट्री एविडेंस नहीं था. उसमें भी आफ्टर दैट डिपार्टमेंट लेवी ऑन द टैक्स. माई केस ग्राउंड ऑफ अपील है जो हमारी ट्रांजैक्शन है वो सेक्शन 7 शेड्यूल 3 में आती है, जिसके अंदर वो ना तो सप्लाई में आती है, ना सप्लाई ऑफ गुड्स है, ना सप्लाई ऑफ सर्विस है. और इट्स ए लॉन्ग टर्म लीज राइट्स आर बेनिफिट अराइजिंग आउट ऑफ लैंड ओनली. वी आर नॉट ट्रांसफर द राइट टू द right of our land to the XYZ Limited. Well, just we are leasing our land to the XYZ Limited. इसी एक केस अभी गुजरात हाई कोर्ट में आया है, गुजरात चैम्बर ऑफ कॉमर्स का. उसमें गुजरात हाई कोर्ट ने फेवर में क्लाइंट के दिया है कि उन्होंने गुजरात हाई कोर्ट ने माना है कि सेक्शन 7 शेड्यूल 3 के अनुसार जो ये ना सप्लाई में आएगा, ना गुड्स सप्लाई ऑफ गुड्स है, ना सप्लाई ऑफ सर्विस है, सो इस पर जीएसटी लेवी नहीं हो सकती है।
इसका कोई पर्टिकुलर पैराग्राफ आप पढ़ के बताना चाहेंगे?
जी
ये लीज जो है, इज दिस लीज फॉर अ शॉर्टर पीरियड और अ
सर,
लॉन्गर पीरियड?
दिस इज नॉट अ लीज, दिस इज असाइनमेंट।
असाइनमेंट
Lease as vis-a-vis assignment. So this document is for a limited period or for a broader period, longer period.
So with a longer period.
but you have not mentioned anything.
I might mention
कहीं पर भी नहीं आपने लिखा।
Okay, this is for the longer period. Though you are mentioning in your judgment that this is for the 99 years lease in that judgment, but in your grounds or in your other things you have not mentioned this fact.
Yes, go ahead with the judgment.
जजमेंट के पैरा नंबर 67 में लिखा है,
पेज बताइए।
दो 280 पेज की जजमेंट है, दिमाग खराब कर दिया इसने।
It is followed by Bombay High Court.
Yes,
That's another longer judgment.
a lot of lawyers.
पेज नंबर 32 पैरा नंबर 32।
Allowed on page 8, he has mentioned lease is for 95 years.
Page
8. Officer B. No, I think referring, I'm sorry, he's referring Bombay High Court. Okay, sorry.
However, when such leasehold right is transferred by the lessee assigner in favor of a third person, assignee by execution of deed of assignment, it would be nothing but transfer of an immovable property in view of, in relation of land and building, and includes a lease. The consideration therefore as premium, one-time premium, is a measure on which tax is to be levied, assessed and recovered. Therefore, when the GIDC allows the plot of land of lease of 99 years and charges premium for such allotment, followed by the periodical lease rent to be paid, is to be considered as a supply of service in relation to land and building. Read clause 5. Sorry,
which page है?
32 पे जजमेंट में लिखा हुआ है, पैरा नंबर 63। When such leasehold right is transferred by the lessee assigner in favor of third person assigned, by execution of deed of assignment, it would be nothing but transfer of an immovable property in view of, in relation to land and building, and include a lease. The consideration therefore as premium, one-time premium, is a measure on which tax is to be levied, assessed and recovered. Therefore, when the GIDC allowed the plot of land on lease of 99 years and charges premium for the such allotment, followed by periodical lease rent to be paid, is to be considered as supply of service in relation to land and building. Read with clause 5 of schedule 3, which specifically provides that renting of immovable property shall be treated as supply of service. यदि मैं शेड्यूल सेकंड में आएगा तब उसके अंदर लीज मानी जाएगी, लेकिन जो हमारा असाइनमेंट है वो शेड्यूल 3 में आ रहा है, इसीलिए हमने उस असाइनमेंट में जीएसटी उस पर नहीं लगेगा।
आपके इलाहाबाद हाई कोर्ट की भी एक जजमेंट है, राजीव कुमार एंड अदर्स वर्सेस स्टेट ऑफ यूपी 2017 की जजमेंट है, जो आपके फाइल कर। यस सर।
Now, my lord, the question we are arguing before the tribunal is whether a judgment of Gujarat High Court, Bombay High Court is binding on us by any stretch of imagination. It may have a persuasive value. More so when matter is pending in Supreme Court. All three cases, including Alpha's case, are pending in Supreme Court. There is no stay given by Supreme Court against the judgment or any other direction. Our view is it's covered by Section 7 supply, read with Section 9 and schedule. It is a taxable transaction. The assumption on which those high courts worked was their lease was for 90 years plus, and those lease had a right to mortgage, to sell, to transfer, to assign. Based on these two parameters, High Court said that these are rights of ownership. 95 years, a person's 2 lifetimes. So they said this is nothing but a sale of land. Therefore, where is the question of service? And therefore, no GST. In GST law, we do not have such provisions. This could be the interpretation of a particular High Court, a particular bench. If you go back into land, Your Honor, there are a number of rights given by land. First is when you buy the land originally. Let us say I go to DSIDC and buy a land. This cannot be taxed. Now this land, I construct my factory, no tax. This land I give on rent, situation changes. I create a building, give on rent, situation changes. The land remains same, right? Or let us say I give to a builder in terms of TDR, it is 18% taxable. I sublease, it is taxable. So what happens when I do assignment of a lease rate? Assignment is for a consideration. The transferee, the assignee doesn't become owner of the land. For 95 years, he gets a right to use this land. So to say that we are not covered by definition of supply, based on these 2-3 High Court judgments, including Allahabad was little shorter judgment, these are bigger judgments. Rajiv Agarwal judgment very small. So to say on base those High Courts is a different matter. But even Gujarat High Court, and which was followed by Bombay High Court, Bombay High Court judgment was purely Gujarat High Court judgment. They copied it and said endorsed. So once its matter is pending in Supreme Court, there is no way we can allow exemption. Therefore, notice under Section 74 is valid. We are going to tax them with interest penalty. They have to take a chance. Tomorrow, if we don't tax them today, tomorrow Supreme Court says it's taxable. So revenue cases go for a 6. They become a time bar. After Supreme Court judgment, it's not a ground for reopening a case. Therefore, this notice was validly issued. Notwithstanding, there are 2 judgments or 3 judgments or 4 judgments against us, but those judgments are not Article 141 judgments. Under no constitutional scheme, those judgments are binding upon me.
But Your Honor, since the GST scheme is central scheme, it's a central tax, central act as well. Once any judgment passed by any High Court, right, like in the income tax, that's binding on anywhere in India.
No, Your Honor, I disagree. There was one judgment of Kusum ingots, where lot of people scored. That judgment is totally irrelevant. There, some law were declared unconstitutional. There I agree with my lords, if a law is a circular notice declared ultra-virus or illegal, it's applicable all across the country.
Had the Supreme Court stayed the judgment, then we would say that it's not
But that doesn't matter. What I'm saying is, we are taxing them. You can keep the recovery in abeyance till Supreme Court judgment. We have no issues.
Yes,
We have no issues. But there are no documents annexed whether they fall into paramaterial facts of Gujarat High Court or Bombay High Court. There is nothing on record as such.
So far as this judgment is concerned, they have worked so hard.
That doesn't matter. How does it matter?
But they have laid a law. They have laid a principle.
No, my lord. That principle is based on MSIDC lease deed. Lease deed. We don't know what is this lease deed.
Because this falls in the jurisdiction of the UP. Even the UP High Court has also allowed.
No, but that's again based on a lease deed by UPSIDC. There is no document here. Let them produce a document. We have no objection. Let them debate it before lower authorities. And if tax is levied, we will keep the recovery in abeyance till Supreme Court decision. That's the favor we can show to them.
That can be done.
Yeah, please. No. Supreme Court just I've gone through. Yes, sir.
Do you find any judgment of any high court which shows the revenue on this particular?
No.
Then whatever happens, may assuming, so far we are still in the process of discussing amongst ourselves, assuming that we decide this issue in favor of the appellant, then well, department can also go in for an appeal, and then whatever happens up to the...
I am raising a question, are the judgments binding on daily? That's a question, if criminals say they are binding, I'm with you.
GST, you may say that it is a...
No, now there are n number of High Court judgments in GST regime.
Yeah.
Bombay High Court judgment in 74 independent not binding on Delhi.
I agree.
We have done right from 17 brand equity case, it was not accepted. Loss-sale case was not accepted by any High Court.
It is not applicable as per the DGST is concerned.
I'm discussing GST mechanism.
Along
The
with
case of, my lord, the case of brand equity where they invoked 3-year limitation, it was rejected by all other High Courts. That was also an interpretation of a federal enactment. There is no ruling which is binding. We are talking about taxability. Now supposing my lord agree that they pass this notice. Tomorrow Supreme doesn't agree?
No, today we question.
So what we are fairly saying is, we will create tax liability if we will keep the recovery in abeyance. That's a fair treatment to a client. They are not paying anything to me.
What we feel is that reading Schedule 3, paragraph 5, it says sale of land and subject to clause B of paragraph 5 of Schedule 2, sale of the building. One second.
Yes.
The Gujarat High Court and followed by Bombay High Court, they have only interpreted this part. 1.5 lines they have interpreted that this kind of an assignment right which was given from Gujarat Industrial Development Corporation.
I fairly concede, they say there is nothing but a sale of land.
And my
That's why they say, what I am saying is, if matter was till Supreme Court gives a final verdict, if matter was not pending in Supreme Court, even then I wouldn't have agreed as a revenue concept.
My issue is...
What we are saying is that let tax liability be raised, we will not recover. That's all.
Okay, then to that understanding when to be
Yes,
agree with you.
yes, case can be remanded, we will not recover.
Even for that matter, appellant stands to win.
Yes, let him win. Yes.
But subject to the fact that the recovery will be kept on abeyance.
Yes, that's a fair deal to the appellant. They will not pay anything. But revenue also will not be debarred from the right to tax. If you win, has been. Well done, Himanshu. God bless you.